Yes, Your Honor. Before we proceed, may we introduce ourselves?
Go right ahead.
Good morning, Your Honor. Counsel, members of the jury. My name is Arapahoe, and I represent the plaintiff, Dakota Weirs.
Good afternoon, Your Honor. Counsel, members of the jury. My name is Feliciana Sayers, and I represent the plaintiff, Dakota Weirs.
Good afternoon, Your Honor. Counsel, members of the jury. My name is Moira Newman, and I represent the plaintiff, Mr. Dakota Weirs.
At this time, may our witnesses now introduce themselves?
Yes, please, go ahead.
Good afternoon, Your Honor, counsel, members of the jury. My name is Macklin Gifford, and I am Casey Rogers.
Good afternoon, Your Honor, counsel, members of the jury. My name is Taylor Sipra, and I am Carson Durst.
Good afternoon, Your Honor, counsel, members of the jury. My name is Jordan Merriweather, and I am Dakota Weirs.
Thank you. You may be seated. All right, let's talk to Team X. Team X, are you prepared to proceed?
Yes, Your Honor. Good afternoon, Your Honor, members of the jury. My name is Mallory Hobson, and today I will be conducting the direct examination of Blake Doncourt and the cross-examination of Carson Durst.
Good afternoon, Your Honor, and members of the jury. My name is Danny Gazzelli, and today I will be conducting the direct examination of Dr. Devin Williams and the cross-examination of Dr. Casey Rogers.
Good afternoon, Your Honor, counsel, members of the jury. My name is Kendall Kozlowski, and today I will be conducting the direct examination of Skylar Weirs, the cross of Dakota Weirs, and I will be delivering the closing argument. Permission for our witnesses to introduce themselves.
Yes, please, go ahead.
Good afternoon, Your Honor. My name is Emmy Munn, and I am Blake Doncourt.
Good afternoon, Your Honor. My name is Kate Melman, and today I am Skylar Weirs.
Good afternoon, Your Honor. My name is Stuart Terry, and I am Dr. Devin Williams.
All right, thank you. We had a little echo there. I think we got to figure it out. Okay. Can each side provide the judge and the scoring panelists with copies of your trial roster? Have you done that? Great. All right. I believe that there are video recorders being present and being used. Is it correct that both sides have agreed to taping of the rounds? Yes, everyone is nodding in agreement. I have to inform everyone, as well as folks who are listening in, that the Colorado Bar Association may be taking photographs during the competition, and that the team participation in the tournament grants automatic permission and use of those photos by the Colorado Bar Association. Do we have anyone in the gallery who is connected with the teams not in competing with this round? Don't believe so. All right. I got to remind everyone there's no recesses allowed except for those granted for a health emergency, and especially not between the end of the witness examination and the beginning of closing arguments. The presiding judge shall have discretion to stop time for technical difficulties, crossing our fingers and our toes that we don't have any of those, but they happen. So we'll just roll and deal with them as they come. Let's check in with each of our scoring panelists to make sure that he or her has no reason to be biased in judging either team. Mr. Adams, do you have any concern about bias for either team? Mr. Adams?
No concerns here.
Thank you. Mr. Matisse, any concerns?
No, Your Honor, no concerns.
Thank you. And Ms. Kerrigan, any concerns?
No concerns.
Great. All right. Looks like we don't have any conflicts with our scoring panelists. Got to remind the teams and the coaches that any disputes arising out of this competition must be reported in accordance to competition rules. Remind the teams that their compliance with time requirements will be considered in scoring those individual performances. So let's see. We don't have any coach or team member in the jury box. We've got introductions. One more thing, I'm going off script for just a minute. It is weird to do this virtual. That's okay. We're just going to roll with it. It's weird to stand up when you're on video or not, and it's awkward. Whatever you are comfortable with is fine by me. So if it's more comfortable to sit and present, that's fine. If you, I was a walker and talker. So if you want to stand to present, that's fine by me. You don't need my permission. We'll just roll with that. All right. So I need team members. Please raise your right hands. Team members, do you promise that that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Yes, everyone is nodding in agreement. Witnesses, keep your hands up. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and you will follow the rules and procedures of the mock trial competition? Yes, everyone is nodding in agreement. Don't really have gallery members, so I think I can skip over that. I'll just ask that any teachers or coaches are promising not to represent themselves as positive role models, behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock round. So can't see them on the screen, but just asking that all teachers and attorney coaches follow the rules. And finally, scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible and in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
They're nodding in agreement. All right. Are the parties prepared to proceed to opening statement?
Your Honor, before we proceed to opening statements, the plaintiff has a few preliminary matters.
Absolutely. Go ahead.
The plaintiff has 3 preliminary matters. For our first preliminary matter, we request that the stipulated facts be constructively read into the record.
Any objection?
No, Your Honor.
All right. The court will allow the stipulated facts to be constructively read into the record. Next issue.
For a second preliminary matter, we request that prior to closing arguments, the jury instructions be constructively read into the record.
Any objection from defense?
No, Your Honor.
So granted.
And finally, for our third preliminary matter, we request that while entering exhibits, the attorney and the witness look at the exhibits on their own screen, and then once the exhibit has been published, it may be screen shared.
Any objection from defense?
No, Your Honor.
That is granted as well.
And with that, Your Honor, the plaintiff is ready to proceed.
All right. Any preliminary issues from defense?
Yes, Your Honor.
Go ahead.
Does Your Honor and members of the jury have copies of our team's trial roster?
Do the scoring panelists have that roster?
Your Honor, this is Brian Matisse. I don't believe we do.
Do we have X or Z?
I believe they're in the chat.
They were given to us in the Dropbox. I have them printed in front of me.
I don't see them in the chat. Are they still there?
I don't see them in the chat.
Both should be PDFs in the chat.
Can someone
Your
go?
Honor, they added me as a scoring panelist the last minute, Your Honor, so I don't know if for some reason I didn't get added to the.
With the electronic scoring, I'm not sure that we need to know all the names. So I guess I assumed we didn't have a roster for that reason.
Team X's roster is now in the chat.
I do have that. Thank you.
May I proceed, Your Honor?
Give me just 1 minute here. There's X. And we got X and Z. Okay. Any other preliminary issues that we need to address?
Yes, Your Honor.
Go ahead.
We would ask if we could reserve remaining time for rebuttal at the end of our closing argument.
Any objection?
Yes, Your Honor. As opposing counsel is the defense, they may not request time for rebuttal after closing arguments.
You are correct, as a plaintiff can do so, but defense may not. Next question.
We would ask that all witnesses have copies of the exhibits nearby them.
Response?
No objection, Your Honor.
So order.
We request that the pretrial ruling on November 1st, 2021 be recognized.
Any objection?
No objection, Your Honor.
Pretrial ruling will be the order of the court.
And finally, we would ask that if there are any technical difficulties, that time will be stopped for both teams.
Any objection?
No objection, Your Honor.
Oh my goodness. We're gonna hope we don't have any tech issues, but we will stop the time and fix them if we do.
Thank you, Your Honor.
All right. Any pretrial issues from anyone? Attorneys, witnesses, scoring panelists? All right, I believe we are ready. You may begin. Opening statements.
Green lawns plus green washing equals greenbacks. Young Dakota Weirs was sitting on the couch watching TV when he heard his grandfather begin to play the first few notes of his favorite song. He jumped up to join his grandpa on the piano bench where they sat for hours on end playing the same song over and over until Dakota got it right, till he no longer tripped over the tricky chords. That song became their song. He played that song at his first competition. He played that song at his grandfather's funeral, and he played that song as a part of his audition to Juilliard. A few months later, he opened the big envelope, announcing that he had received a full ride scholarship to the school of his and his grandfather's dreams. But members of the jury, some dreams are too good to come true. Instead of spending his early adulthood at Juilliard, Dakota Weirs was at home, barely able to move about his own house, going from doctor's office to doctor's office until he finally found out it was non-Hodgkin lymphoma. He became too weak to play even the simplest of songs. His cancer not only shattered any hope of a future in music, it robbed him of his closest connection with his grandfather. Good afternoon, Your Honor, counsel, members of the jury. My name is Feliciana Sayers, and together with Moira Newman and Abbott Howe, we represent Dakota Weirs, who had his dreams dashed because Lush failed to prevent the dangers of their product. Both sides carry a burden in today's case by a preponderance of the evidence. A preponderance of the evidence is this: if there are two stacks of paper in front of you, and one stack has even one more page than the other, that side prevails. For Mr. Weirs to prevail, we must prove to you that Lush manufactured a product containing Drufo, that they failed to exercise reasonable care to prevent an unreasonable risk of harm, that Mr. Weirs was someone who should reasonably be expected to use the product, and that Mr. Weirs had damages caused by the defendant's negligence, while the product was being used in a manner the defendant should reasonably have expected. The defense has to try and prove to you that Mr. Weirs did not act as a reasonable person should or would, and that he was the cause of his own damages. They will fail. Let's talk about Drufo. Drufo is a patented bonding agent in Lush fertilizer in order to make green lawns. It bonds the nitrogen to the other chemicals in order to reduce the release of excess nitrates into the soil and water. It is also a pesticide. Lush then marketed Druvo as making their product safer to use and more environmentally conscious. This marketing technique is also known as greenwashing, which is the strategy of labeling unfit products in order to generate more profits. Greenbacks. But members of the jury, let's be clear. Druvo was designed to kill. Its original intention may have been pests and weeds, but a killer is a killer nonetheless. Dakota Weirs used Lush fertilizer and developed non-Hodgkin lymphoma because of his interactions with the chemicals. Dr. Casey Rogers ran his own study on the effects of Druvo and cancer, and Carson Durst worked within Lush fertilizer and saw them acknowledge and suppress Druvo's ties to non-Hodgkin lymphoma. Like Don Court, the CEO of Lush cares more about generating profits than safety. Skylar Weirs has misguided views on modern agritech, and Dr. Devin Williams will demonstrate that Lush fertilizer and the other fertilizers are comparable and even more dangerous than Lush would care to admit. During today's trial, ask yourself these 3 questions. 1, did Lush do enough to protect their customers from the potential dangers of their product? 2, do we expect a 14-year-old to be able to protect himself from dangerous chemicals? And 3, how safe is Druvo? Really? At the end of today's trial, Ms. Newman will walk with you through the evidence presented today. She will show you how we have met our burden by a preponderance of the evidence. And she will ask you to hold Lush fertilizer liable for their negligence by not properly warning the users of the dangers of their product. Green lawns plus green washing equals greenbacks. Thank you.
Thank you. Defense open?
Yes, Your Honor.
You may begin.
Good afternoon, Your Honor, counsel, and members of the jury. My name is Danny Gazzelli, and I represent the defendant, Lush Fertilizer, in this case. And today, this is a case about relying on science over speculation. It is the sad truth that the plaintiff has been diagnosed with non-Hodgkin's lymphoma. Yet, we are not here to debate this diagnosis, but rather the cause. Mr. Dakota Weirs is here attempting to prove that their use of a Lush fertilizer containing Druvo is the cause of their non-Hodgkin's lymphoma. The plaintiff has to support that conclusion, but the evidence, the science, will show that this is simply not true. While we acknowledge Mr. Weirs' terrible disease, you are being asked today not to determine whether Mr. Weirs has cancer, but whether their cancer was caused by Lush Fertilizer's product. And ladies and gentlemen, today the evidence you will hear does not support the plaintiff's conclusion. The burden of proof today falls on the plaintiff. They have to prove by a preponderance of evidence, meaning it is more likely than not, that Lush Fertilizer failed to exercise reasonable care in the production and use of their fertilizer. At the conclusion of this case, we will ask you to find that the plaintiff failed to meet this burden. The defense will show the extensive research put into Druvo and every step taken to ensure its safety. You will hear that there is no credible evidence linking Druvo to non-Hodgkin's lymphoma in humans, despite the plaintiff's efforts to tell you otherwise. In order to disprove the plaintiff's claim of negligence, we will present 3 witnesses. First, you will hear from Lush's CEO, Blake Doncourt. Doncourt will testify to the time and energy she has put into this company, ensuring that Lush is sustainable, successful, and environmentally friendly, all while providing cutting-edge products to the public. Her testimony will show that through Lush's extensive research, development, and testing of Druvo, there were 0 scientifically based concerns about any harmful effects. Next, you will hear from Skylar Weirs, Dakota's twin sister and an expert in the agritech industry. She will testify to not only the benefits of Druvo, but how it is the safest fertilizer on the market. Her testimony will describe how her Drufo-specific research found that it was a complete myth that there were any harmful side effects to the use of Drufo. Last, you will hear from Dr. Devin Williams, a toxicological specialist who has worked for Lush for nearly a decade. She will not testify to the fact that this data showed that Drufo had no correlation to any serious health conditions, but also share her expert opinion on why the only research the plaintiff has provided regarding Drufo being carcinogenic is scientifically flawed. Members of the jury, if you hear this scientific testimony and still decide to rule on the plaintiff's side of speculation, you will then be asked to consider whether the plaintiff's own conduct contributed to her injuries. It is up to you to determine if Mr. Dakota Weirs was also negligent, and today the defense will show that Dakota Weirs was in fact negligent. Mr. Weirs himself will testify that he did not follow the manufacturer's safety recommendations or the safety recommendations from his employer. You will also hear from the plaintiff's expert witness, Dr. Rogers, who will testify that their recommendations regarding Drufo are the same as those Mr. Weirs failed to follow. We recognize Mr. Dakota Weirs' anger at their diagnosis, but in this anger, they are scapegoating Lush, an upstanding company with products that have no carcinogenic effects. The plaintiff failed to consider the many other fertilizers that they used during their landscaping career. In fact, they failed to consider any other possible causes of their cancer. Because of this, the evidence the plaintiff will present will be rooted in speculation. And so, we ask that you rule in favor of science and find the defendant not liable for negligence in this case. Thank you.
Thank you. All right, plaintiff, call your first witness.
The plaintiff calls Dr. Casey Rogers to the stand.
Dr. Rogers, you may begin.
Good afternoon, Dr. Rogers. My name is Moira Newman. Could you please introduce yourself to the jury?
Yes, my name is Casey Rogers. Rogers is spelled R-O-G-E-R-S.
And Dr. Rogers, what do you do for a living?
I am a professor in horticulture and entomology at the University of California at Berkeley, as well as an independent toxicology researcher.
How long have you been working in this field?
Almost 2 decades at this point.
Tell the jury about your education.
I have a Bachelor in Science in Agriculture and Chemistry from Colorado State University, as well as a PhD in Agriculture and Entomology from the University of California at Berkeley.
Have you authored any publications?
Yes, I have authored numerous publications.
What are some of those publications?
I have published 6 in total. However, the more recent ones that are specific to this case would be in 2013 in weed biology, my apologies, in evolutionary sciences. I published an article called Drufo-resistant weeds. In 2017 in biotechnology information, I published an article called Drufo Toxicity and Carcinogenicity, a review of the scientific basis of the European Union assessment. In 2019, I published an article in weed biology called Survey Reveals Frequency of Multiple Resistance to Drufo. Again, in 2019, I also published an article in The Environmentalist called The Evidence of Human Exposure to Drufo, a Review.
Wow, what are you working on now?
Currently, I am working on a study to test the efficacy of certain protective equipment in preventing the harmful effects of exposure to Drufo on certain non-target species.
At this time, the plaintiff requests the court recognize Dr. Casey Rogers as an expert in horticulture and entomology, and as well as toxicology research, as his skill, education, experience, knowledge, and training have all been shown, and his opinions and conclusions will assist the trier of fact in determining a fact and issue today.
Any objection?
Yes, Your Honor. Permission to perform a voir dire.
You may proceed.
Dr. Rogers, you were not a pre-med major, correct?
I don't list being one, correct?
You have no medical degree,
I work in toxicology, which is a more specialized field rather than just getting a general med degree, counsel.
but you don't have a medical degree, correct?
Correct. However, I do have degrees in multiple medical fields.
Thank you. You have no advanced education in medicine,
Can you define what you mean by advanced education?
possible residency or fellowship in the field of medicine,
I work as a professor, not at a hospital, counsel.
and you also have no experience working in the medical field, correct?
I've been a toxicology researcher for almost 20 years. I would say I have plenty of experience in the medical field.
You have not worked at a hospital though, correct?
Of course not, because I researched effects of exposure of certain chemicals, not dire things such as people coming in with open heart surgery.
Your Honor, based on the witnesses' responses, I ask that any expert testimony is limited to exclude rendering a medical opinion, including any testimony concerning alleged ways in which Drufo could supposedly affect a non-Hodgkin's lymphoma diagnosis.
Response.
Dr. Rogers testified to having over 20 years of experience in toxicology research, as well as publishing numerous articles on the subject. Therefore, he has shown extensive education as well as training and experience in toxicology research. We are not offering him as a medical expert, simply as a toxicologist, which he has shown immense expertise, education, knowledge, which satisfies mock trial rule of evidence 702.
Finds that based on the testimony and the information presented to the court, that the court will qualify the witness as an expert in horticulture, ophthalmology, and toxicology. You may continue.
Yes, Your Honor. Dr. Rogers, did you develop any expert opinions pertaining to this case?
Yes, I have.
What were the steps you took to reach this opinion?
I conducted a study to test if there were any adverse effects or negative effects in people who were exposed to Drufo over a long period of time.
You mentioned Drufo. Tell the jury what that is.
Drufo is a patented bonding agent that Lush uses in all of its products distributed throughout the United States. And its job is specifically to keep the nitrogen in the fertilizer preserved and intact over a longer period of time.
Considering this information, why did you conduct a study looking into the adverse effects of Drufo on people?
Well, briefly after Drufo was released on the market, I had already begun hearing rumors about possible negative effects of exposure to Drufo, and so I decided that I should conduct a study to test if there was any truth behind those rumors.
How did you conduct your study?
I conducted my study with 3 test groups. One was a group with prolonged exposure, one was a group with occasional exposure, and the third group was a control group who had no exposure to Drufo whatsoever.
Why did you choose these groups specifically?
These groups already had people who could be fit into their categories, who had the exposure levels to Drufo that I wanted, and therefore I would not be needing to subject certain people to a possibly deadly substance that they were not already in contact with.
Were you confident in the results they produced?
Absolutely.
Why?
Well, I use very reliable scientific methods that are common practice in my field, and I conducted a study that strictly adhered to them.
Now, speaking of those results, tell the jury what the results of your study were.
Objection, leading question.
Response.
This is an open-ended question, as Dr. Rogers can respond in any way as he would like to. This is not leading him to any one specific answer, as in yes or no.
Court finds that tell the jury the results is not a leading question. The court will overrule the objection. Mr. Rogers, do you need the question repeated or are you prepared to answer?
I can answer, Your Honor.
You may go ahead.
My study found that people who had prolonged exposure to Drufo were 10 times more likely to develop cancer as compared to the control group. And those who had a more occasional exposure level were 5 times more likely compared to the control group to develop cancers.
You mentioned cancers. Why specifically cancers and not any other adverse health condition?
Well, I was looking for any health condition that may arise as a result of exposure. However, cancer became the forefront of my statistics, being that it happened more often than really any other health condition. And the cancers that I found were specifically endocrine and exocrine-based varieties.
Outside the scope of the witness's expertise.
Explain your
Response, Your Honor?
objection. Hold on. Explain your objection a little further.
Your Honor, the witnesses was testifying to endocrine versus exocrine variants of cancer, and I believe this falls outside of their expertise in horticulture, entomology, and toxicology.
Response?
Dr. Rogers is an expert in toxicology research, therefore he would be able to know what the adverse effects of the different chemicals on his patients would be. And as he has written numerous articles about the effects of different chemicals on the human body, he would know the health conditions of the patients.
I will allow the testimony, noting that this is subject to cross-examination. You may proceed.
Would you like me to re-ask the question, Dr. Rogers?
Yes, please.
Why specifically did you find cancers as being the adverse health conditions?
Well, I was looking originally for anything that could arise, obviously, because I was trying to test if it was a deadly substance. However, cancer became the most common diagnosis in my test subjects, and I decided that I should look into that. Specifically, the cancers that arose were endocrine and exocrine-based varieties, the latter of which includes non-Hodgkin lymphoma.
Why does the latter of which include non-Hodgkin lymphoma?
Well, it is an exocrine-based cancer variety, and it was commonly developed in my test subjects as a result of their different exposure levels to Drufo.
Did your study test for anything else?
I conducted another study to test if certain protective equipment would actually have an effect in preventing exposure to Drufo so that the negative effects could be minimized. However, that study is inconclusive as it is still ongoing.
What do you expect this specific part of your study will result in?
Well, to be quite honest, I don't have much information that has come out of the study. However, I can hope that it will show that certain protective equipment will protect people from developing cancer as a result of exposure to Drufo. However, I cannot guarantee that that is what protective equipment will do.
Did you do anything to prepare for today's trial?
I read Dakota Weir's medical and employment records.
After reviewing all of this information, what did you learn?
Well, the most important thing that I noticed was that Dakota Weir's had a very, very similar exposure level to those in my study who had prolonged exposure to Drufo and developed 10 times as much non-Hodgkin lymphoma, cancer in general, but most often non-Hodgkin lymphoma as compared to the control group.
Now, a little earlier, I asked if you had formed any expert opinions for today's trial. Please tell the jury what that expert opinion is now.
Dakota Weir's non-Hodgkin lymphoma was caused by exposure to Drufo and to Drufo only.
Objection. Witnesses' scope of expertise.
Response?
Your Honor, Dr. Rogers is testifying as to the results of his study, as well as all the information that he reviewed in preparation for today's trial. Therefore, his expert opinion is not outside the scope, as he is basing this in his specialized knowledge as an expert.
Reply?
Yes, Your Honor. Based on the results of this study, it does not apply directly to Dakota Weir's, as well as I believe that this is, again, a medical opinion that there's no way to know for certain.
The court would find that it may have some relevance and is within his scope of expertise. So the court will overrule the objection and allow the testimony. You may continue.
Would you like me to re-ask the question, Dr. Rogers?
No need. Dakota Weir's non-Hodgkin lymphoma was caused by exposure to Drufo and to Drufo only.
And why are you so sure that it was Drufo that caused the cancer in today's trial?
Well, being that he had such an incredibly similar exposure rate to those in my study who developed cancer at a 10 times higher rate than those who were not exposed to Drufo, I would say that is very, very strong evidence to show that it was caused by exposure to Drufo.
Thank you. No further questions at this time, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Dr. Rogers, this is the first time you have ever testified as an expert witness, correct?
Every expert has their first time, and this is mine, so yes.
And you stand to make money for your testimony in this case?
I do not
Your Honor, relevance?
The objection is relevance. Response?
Yes, Your Honor. This question goes towards the witness's potential bias in this case.
Court will overrule the objection. You can ask the question again.
And you stand to make money for your testimony in this case?
That's not my statement. Would you like me to answer?
Sorry, Dr. Rogers, on line 1 of your statement, you stated that you are being retained as an expert witness, which means that were being retained.
Your Honor, improper impeachment.
Let her finish the question. Go ahead and finish the question.
Thank you, Your Honor. On line 1 of your statement, you state that you are being retained as an expert witness. Isn't it true that you are being paid as an expert to be here today?
Wait just a minute. Go ahead. Was there an objection?
Yes, improper impeachment. She has not asked specifically whether Dr. Rogers is being retained, simply that he was being paid.
The court will overrule the objection and allow the witness to answer the question.
Yes, Your Honor.
May I answer?
Ms. Gazzelli, it is completely possible for someone to be retained without being paid. It is a common practice in the field of law.
Thank you. You are hoping that you will get to testify in more cases after this, correct?
Absolutely. I want to help other people who have been exposed to Drufo and developed cancers as a result.
And you do a lot of research, right?
Yes, I do.
Your recent publications center around Drufo and its alleged harmful effects?
Correct. Not only on humans specifically, but I also publish articles specifically detailing that Drufo is not as environmentally friendly as it's advertised.
4 out of 6 of your total publications relate to Drufo, right?
Specifically Drufo, correct.
Let's transition to look at your expertise surrounding Drufo. When looking at toxins, they are absorbed through the skin, correct?
That's one of the ways that toxins are metabolized, yes.
Or they can be inhaled.
That's the other major way.
So because of this, you believe that those who use Drufo should wear long sleeves.
Well, I believe that people who are being exposed to potentially deadly substances should protect themselves in any way that they can. And I cannot prove that wearing long sleeves will help, but it definitely wouldn't hurt.
And you also believe that those who use Drufo should wear long pants, correct?
I believe the recommendation I made off of the data in my study that still has not fully shown any evidence was to prevent contact with skin majorly. However, you could say that wearing long sleeves and long pants would be one of the best ways to do that, correct?
I apologize. I don't mean to be rude, but I have a limited amount of time for this exam, and I would appreciate if you tried your best to answer with yes or no statements, and your attorney can clarify any responses that you give on redirect.
I'll answer to the best of my ability. However, a yes or no answer requires a yes or no question.
And wearing long pants and long sleeves are all measures taken to avoid absorption through the skin, correct?
Like I said, I can't prove that that is actually an effective method, but again, like I said, it couldn't hurt.
And in your expert opinion, you believe that those working with Drufo should wear a mask.
That's not an expert opinion. That's a recommendation based on data that has not come back from an ongoing study.
So in your recommendation, you believe that those working with Drufo should wear a mask.
Once again, it couldn't hurt, but I can't show that it can help either.
And these are all precautionary safety measures those using Drufo should take, right?
To protect themselves in any way from a carcinogenic substance, yes.
Because in your opinion, these measures would reduce exposure and related risks of Drufo, correct?
That's what I'm hoping to find out of my study. However, once again, it is inconclusive as the study has not been completed.
But you do believe that these measures would reduce exposure and related risks of Drufo, correct?
Your Honor, asked and answered.
Response?
Your Honor, I feel that the witness did not answer the question.
I'll overrule the objection. Doctors, to answer the question. Go ahead and ask the question again.
But you believe that all of these measures would reduce exposure and related risks of Drufo, correct?
I believe it's possible. However, I do not have data to back that up.
And in your review for the case, you found that Dakota Weirs used Drufo without any skin protection, right?
Correct.
Or any kind of face covering?
Correct.
Let's talk about your study. This was a study that you personally conducted.
Absolutely. I'm very proud of it.
You looked at 3 groups of people?
Yes,
A group who was never exposed to Drufo.
that was my control group.
A group who was exposed occasionally.
That's one of the other test groups, yes.
And a group who was regularly exposed.
I believe I more often said prolonged, but yes.
Those exposed to Drufo contained farm laborers and gardeners, right?
Correct, yes. Those were 2 groups who used Drufo on the right exposure basis. So I decided that I should use them in my study.
Of course, occupationally, farmers and gardeners are typically exposed to other pesticides during their work, right?
Honestly, it really depends. Some are organic farmers. Some would probably be loyal to Lush, being that it is falsely advertised as an incredibly environmentally friendly product.
And you didn't provide us any information about their possible exposure to pesticides during your study, did you?
About exposure to any pesticides or exposure to Drufo?
You didn't provide us any information about farmers and gardeners' possible exposure to other pesticides during your study, did you?
Of course not. It's a given. I was measuring for Drufo, not other pesticides.
And farmers and gardeners can also be exposed to other kinds of fertilizers, right?
Which is why I had them in separate groups, because then the variations in their job titles would get lost in the noise.
But yet again, you didn't provide us any information about whether or not other fertilizers were used for the duration of your study.
And yet again, I was studying for Drufo, not for exposure to other pesticides.
You found an increase in serious health conditions for those exposed to Drufo, correct?
Yes, that's what my study was able to find.
And those exposed included farmers and gardeners?
Yes.
But based on the information you provided here today, we have no way of knowing that Drufo was the only chemical difference between these 3 groups, correct?
Being that my control group was only being controlled for exposure to Drufo and not to other pesticides, it is a given that all groups could be exposed to pesticides, and I did not specifically detail exactly who was in each group. I simply said that farmers and gardeners were across the 2 groups who had exposure to Drufo.
Dr. Rogers, that was not my question. I'm saying that because of the information you provided today, there's no way for us to know that Drufo was the only difference between your 3 different groups, correct?
And my answer was that the only chemical that I was testing for was Drufo because I had different people in different groups, and therefore exposure to different chemicals would be lost in the noise.
Thank you. No further questions.
Redirect.
Yes, Your Honor. Dr. Rogers, why did you choose the groups that you studied specifically?
I chose them because I would not be having to subject other people to a substance that was potentially deadly.
And why did you believe they produced reliable results?
Because I used the scientific method on my study, as well as other very common practices in my field of mixing test groups. For instance, having farmers and gardeners in one group, farmers and gardeners in another group.
Did the slight occupational differences between farmers and gardeners affect your study in any significant way?
Absolutely not. They were in different test groups and therefore would not have an effect on my study, being that they were merged together into different categories.
Thank you. No further questions, Your Honor.
Thank you. This witness may be excused. Plaintiff's next witness.
Your Honor, the plaintiff calls Carson Durst.
All right, we have Carson Durst. You may begin.
Good afternoon, Ms. Durst. Could you please introduce yourself to the jury?
My name is Carson Durst. That is spelled D-U-R-S-T.
Ms. Durst, what do you do for a living?
I am the lead product developer at Terra's Greenery.
Before you worked at Terra's Greenery, where did you work?
I was employed at Lush Fertilizer as their product development engineer.
So why do you no longer work at Lush Fertilizer?
When I was working at Lush, I did not believe that they appreciated my talents and hard work, and so I went to go look for a job elsewhere, and I was hired by Terra's Greenery.
After you left Lush, did anything happen?
Yes, when I was hired by Terra's Greenery, not too many days later, I had been fired by Lush Fertilizer and legal action was taken against me.
What kind of legal action did they take?
Lush sued me for breaching my non-compete agreement, and then not too long after that, Lush and I settled in court, and I have been working at Terra's Greenery for the past 16 years.
Going back to your time at Lush Fertilizer, what did you do there?
My job was to develop Drufo on Lush's fertilizer and research team.
We heard Dr. Rogers testify as to what Drufo was, but why was Drufo so important?
I believe Drufo was important because it gave Lush a competitive edge on the market, and it was one of the front runners for fertilizer products that people bought.
Specifically with Drufo, what did you do?
So Lush did an in-house study into the effects of Drufo, and my job was to research one of the chemical compounds called nitrogen phosphorus carbonate, or better known as C3NO9P.
In your research of this particular chemical, what did you find?
As I was researching, I found something kind of concerning. I found a study on the effects of this chemical and how it related to rats.
Who conducted this particular study that you found?
It was done by the Mattis Bernard Cancer Research Center.
What is your understanding of how they conducted this study?
When I read the research report, the information that I took away from it was that this chemical compound was given to both groups of male and female rats at different stages throughout their lives, starting from 12 days to natural death in their feed. And the ones these rats died, their remains were analyzed.
After researching this study, what were you able to learn?
I learned two things. I learned that Drufo, this chemical compound causes cancer in rats, and exposure at a younger age increases the chances of developing any type of adverse health effect.
So after learning this from this study, what did you do with your findings?
I documented them in my lab notebook on June 10th of 2003, and I believe that my manager, Jay Langley, reviewed these findings.
What other research into the safety of Drufo did Lush do?
Lush did a second study into the possible effects of Drufo are but on humans. And I received an email about this on September of 2003.
Ms. Durst, could you please refer to Exhibit 4?
Yes,
Do you recognize this document?
I do.
What is it?
It was an email sent from my boss about the second study that Lush did.
And who was your boss that sent this email?
My boss was Jerry Langley.
And is this a fair and accurate representation of the email as you received it?
Yes, it is.
Your Honor, at this time, the plaintiff requests that Exhibit 4 be admitted into evidence as its accuracy and authenticity have been shown.
Any objection to Exhibit 4?
Yes, Your Honor, hearsay and authenticity.
Response?
Your Honor, to the objection as to hearsay, this email is not hearsay under Rule 801D2, as it is a statement from a party opponent, that party opponent being Lush Fertilizer. And as to authenticity, Ms. Durst has testified that she did indeed receive this email, and that this copy is an authentic and accurate copy of that email.
Court will admit Exhibit 4 over objection. You may continue.
Your Honor, may my co-counsel now publish this exhibit by screen sharing?
Please.
Ms. Durst, where is your name on the email recipient list?
My name is on the first line at the end, the last name, Carson Durst, before the or after the name Carrie.
And is Blake Doncourt's name also on this email list?
Blake Doncourt's name is right after my name.
All right, you may now take down Exhibit 4. So in this second, Ms. Durst, why was this study, or why was this email so important?
To me, this email was important because it said that Lush had done previous studies and found possible carcinogenic qualities in this chemical. And so Lush was going to conduct another study. And also the first study done by Lush was not labeled conclusive.
So in this other study that Lush conducted, what were some of the findings that were presented?
I learned that not only does Drufo contain a carcinogen, but there's also a link between Drufo and non-Hodgkin's lymphoma.
When this finding was presented, who was in the room?
So in the room, it was my research and development team along with Jerry Langley, my boss, as well as Alex Monroe, another member of Lush's management team, was there to listen to everything.
After this study was completed, did Lush prepare an official report?
Yes, they did.
And in this report, was there any mention of a measure that Lush could take to make their fertilizer products safer?
Actually, there was, yes.
And what was that recommendation?
The recommendation was to bake Drufo to eliminate any possibility of it being carcinogenic or causing any adverse health effects.
This recommendation to bake Drufo, did it seem to you that Lush took their own recommendation here seriously?
To be honest, I don't think that they did. I think they just made it to sound like they were going above and beyond what was necessary to comport with safety standards.
And Ms. Durst, was there any mention in the entire report of a possible link to non-Hodgkin's lymphoma?
No, and now that I think about it, the words non-Hodgkin's lymphoma were not in the report at all either.
And was non-Hodgkin's lymphoma something that was brought up during the meeting?
Yes, one of the researchers did bring up a link between non-Hodgkin's lymphoma and Drufo.
No further questions at this time, Your Honor.
Cross-examination. You may proceed.
Miss Doncourt's son, Charles, and you were lifelong friends, correct?
Blake and I, you could say we were besties. We played soccer together, spent summers at the lake house. We had Sunday dinners. He was my best friend, yeah.
And you two were so inseparable, you even went to college together.
Yeah, ASU.
And like most college students, you were inexperienced.
I hadn't had a job yet. Yeah.
And Charles, being your best friend, put in a good word for you with his mom.
His mom did not run the company, no.
I believe Charles' mom was Miss Doncourt.
Yes.
Thank you. And once you got to Lush, they made you sign a confidentiality agreement.
I signed a lot of papers in that day. I was so excited to just start working, but I did sign yes.
And this is pictured in Exhibit 5.
Yes, it is.
Your Honor, let the record reflect, I'm asking the witness and my opposing counsel to refer to Exhibit 5.
The record will so reflect. You may continue.
Ms. Durst, is this the agreement between you and Lush?
Yes, it is.
Is that your signature at the bottom of the page?
Yes.
Is this a fair and accurate copy?
Yes, it is.
Your Honor, let the record reflect that at this time, I move for the admission of Exhibit 5 into evidence.
Any objection?
Your Honor, I object to hearsay and relevance.
Response?
Your Honor, I believe this is not hearsay because it is a court document. And for relevance, this goes to the witness's credibility, which I will further proceed to question her about.
Court will admit Exhibit 5 over objection. You may continue.
Thank you, Your Honor. Permission to publish to the jury?
You may do so.
Thank you. Ms. Durst, this agreement states that you cannot work for any company that would benefit.
Objection, Your Honor. Hearsay.
There's an objection to hearsay.
Your Honor, I believe this is not hearsay because the exhibit was just admitted and is on the screen.
Response, Your Honor.
Yes, sir.
This exhibit, or this testimony is hearsay, as counsel is asking Ms. Durst to testify what this exhibit says. And what this exhibit says is a statement that has been made out of court and is for the truth of the matter asserted.
So the question is asking the witness about information that is contained in Exhibit 5, which has been admitted into evidence. And so the court will overrule the hearsay objection and allow the question to continue. Why don't you start back at the beginning? Go ahead.
Thank you, Your Honor. Ms. Durst, this agreement states that you cannot work for any company that would benefit.
Cumulative.
Response?
Can you please repeat that?
Your Honor, this evidence that counsel is asking Ms. Durst to testify to is cumulative to the already published exhibit.
Response?
Your Honor, I believe it is not because it is there in Statement 2.
The question is asking about the contents of Exhibit 5. And so the court does not find that it is cumulative, as the witness has not been asked questions specifically about the exhibit. Overruled. You may continue.
Ms. Durst, would you like me to restate my question?
Yes, please.
This agreement in Statement 2 says that you cannot work for any company that would benefit from a disclosure of Lush's trade secrets.
This agreement did say that, yes.
And I'm sure, as you are very knowledgeable, you understand that this is a legal document.
Yes, I do know that. I'm aware of that.
Okay, now that we've covered that, let's move back to what happened when you worked at Lush.
Okay, sounds good.
After 3 months at Lush, you had already become a product development engineer.
I had taken a summer internship in June, and Lush and Blake Doncourt must really like the research that I was putting out, and so they hired me on as a full-time employee, yes.
But unfortunately, as time passed, your work became more and more criticized.
Unfortunately, it was. It was sad to see that my hard work was not being recognized and I was not getting the credit that I deserved.
And eventually, your higher-ups made you sign a performance improvement plan.
Going on that plan was supposed to get Lush and I into a better position, but unfortunately, that did not happen.
And when you went to Miss Doncourt, your lifelong mentor and close family friend, even she refused to intervene on your behalf.
That is correct, yes.
And as you say in your statement, this made you feel betrayed by Miss Doncourt.
As you said, I thought I could get help from her. I thought that I would get some coaching, but that just didn't happen.
But you created a plan for revenge to make Miss Doncourt feel betrayed in return.
I went to look for a new job. I did not create a plan for revenge.
And you knew how much Miss Doncourt hated her competitor, Tara's Greenery.
In the moment, I had that thought because I was really upset with the way she reacted to my conversation, but that was just a passing thought. That was not the reason why I left Lush, to be clear.
And after the issues you'd been having, you did apply for a job there.
I realized that my future at Lush, I was not going to have one, and so I needed to look out for myself, and I needed to go somewhere else where I would get better support and better coaching, and Blake Doncourt just was not going to offer me that, unfortunately.
And just to refresh from a little bit earlier in this exam, you signed a contract saying that you would not work for any company.
I'm sorry, was there an objection?
Objection, Your Honor, to asked and answered.
Response?
Your Honor, I'm asking this to refresh the members of the jury for my next line of questioning.
I'm going to sustain that objection. Next question.
Ms. Durst, Tara's Greenery would benefit from Lush's trade secrets.
No, they would not. Tara's Greenery and Lush's products are two different products, but they are both fertilizer.
And they are main competitors.
They're in the same industry, so that is to be expected.
And so you broke your legal promise you had made.
I had to go work for another company. This was not the right company for me. I did it. It was not in bad faith.
Ms. Durst, even if it wasn't in bad faith, you still accidentally broke your legal promise that you had signed to.
I accidentally breached it, but I had to do what's best for me. And yeah.
Okay, let's go back to your work at Lush. At Lush, you were part of the research for Drufo.
I was first an intern, and then I was there an engineer, yes. And so I did develop and research Drufo with them.
Yet you say you did not have all the access to the data.
I was an intern, and so I just did what my boss told me to do, and I gave her the information that she wanted.
You were not a scientist conducting these experiments.
I did some research, and I was there and present during some of the meetings where we learned a lot about Drufo and a lot about.
Sorry, I believe that was not my question. I'm asking for simple yes or no statements, please. I said you were not a scientist conducting experiments.
I was a development engineer.
You had no PhD.
No, I did not, but I have a bachelor's degree.
You even say yourself in your statement that baking
Hearsay.
I'm sorry, hearsay.
As to what Ms. Durst said.
You'll have to explain that objection a little bit further.
Your Honor, counsel asked Ms. Durst to testify as to what she said. So I am objecting to hearsay on as what she said.
Court finds that that is not a proper testimonial objection, and the court will overrule it.
Thank you.
Continue.
Ms. Durst, you even say yourself in your statement that baking the fertilizer was said to be going above and beyond the safety standards.
I believe that is what Lush felt about it, and I believe that is why Lush made the recommendation.
Drufo being carcinogenic was simply a possibility, but nowhere near being definite.
Drufo was carcinogenic, and a possibility is very definite.
Okay. Ms. Durst, you even admit, based on what you saw in the report, that there was no specific mention of non-Hodgkin's lymphoma anywhere in this report.
Actually, it was mentioned in the meeting where Jerry Langley and Alex Monroe were there, but not in the report, which I found interesting because members of Lush's team were there to listen, but they didn't translate that into the report.
So is that a yes?
Yes.
Thank you. I have no further questions.
Redirect?
Yes, Your Honor. Ms. Durst, do you still hold any animosity towards Blake Doncourt?
I am really grateful and appreciative for his coaching and support as an intern and one of my first jobs, but I hold no animosity toward him.
And why are you testifying here today?
I'm testifying here today because I know that Lush has created a carcinogenic product that has hurt people, and that cannot be continued, and that product cannot be continued to be sold.
No further questions, Your Honor.
Thank you. The witness may be excused. Next plaintiff's witness.
Your Honor, the plaintiff calls Dakota Weirs to the stand.
All right, a witness has appeared. You may begin.
Good afternoon, Mr. Weirs. My name is Feliciana Sayers. Please introduce yourself to the jury.
Good afternoon. My name is Dakota Weirs. That's spelled W-E-I-R-S.
Mr. Weirs, what do you do?
Well, the truth is, I currently don't do much, and that's because I can't do much because of my illness.
What kind of illness?
Recently, I was diagnosed with non-Hodgkin's lymphoma, a cancer.
What did you do before you were diagnosed with cancer?
Before I had cancer, I truly felt alive. I was an active member in my community. I would help out at local homeless shelters and get good grades, but one of the aspects I enjoyed most about my life before cancer was playing piano.
Why did you enjoy playing the piano so much?
Objection, Your Honor. Relevance?
Your Honor, this is highly relevant. Your Honor, this is highly relevant. It is one of the central point of this case is arguing emotional damages. Mr. Weirs being denied the opportunity to play the piano because he developed non-Hodgkin lymphoma from Lush's product. This is highly relevant.
Any response?
Yes, Your Honor. Respectfully, I don't believe that Mr. Weirs' love for the piano has anything to do with whether Lush fertilizer caused his cancer.
Based on the nature of the petition and the damages requested, the court will find that the testimony is relevant and the court will overrule the objection. You may continue.
Mr. Weirs, why was the piano so important to you?
Well, whenever I played the piano, I just got in my own world and I could just vibe with the music and let it take me wherever it took me. But one of the most important things about the piano was the connection it built between me and my grandpa, who sadly passed away. And whenever I played, it felt like he was just right there watching me.
I'm sorry to hear about the loss of your grandfather, Mr. Weirs. Were you any good at playing the piano?
After some time in playing, I became quite good. I used my grandfather as inspiration to get better.
Did anything come from your skills?
Yeah, I got accepted into my dream school, Juilliard. I got a full ride scholarship. I mean, my grandpa would be so proud.
Did you end up attending Juilliard?
No, I didn't end up going there because around the time I was leaving for college, I started developing some symptoms. I had rapid weight loss and I was constantly tired. I had no idea what was wrong with me.
What did you do?
I went from doctor to doctor just trying to figure out what was wrong with me, and eventually one of the doctors diagnosed me with non-Hodgkin lymphoma.
How has this impacted, or what kind of symptoms do you experience with non-Hodgkin lymphoma?
I'm constantly experiencing sharp chest pains, rapid weight loss, and I'm always tired. I can't even sit in places for a long amount of time without bruising.
How has this impacted your life?
Oh, feels like I can't do anything but sleep or lay on my couch anymore. I can't even play the simplest of songs on my piano. Most of all, my future has been ruined. I can't go to the college of my dreams.
Speaking of non-Hodgkin lymphoma, have you been in contact with Truffaut?
Yeah, back when I worked at Havens Landscaping, I was, yes.
What is Havens Landscaping?
Oh, back when I was 14, I needed a job to save up for college, which I realized was pointless now, and I decided to work at Havens.
And how do you know what Truffaut is?
One day I was sitting on my couch, as I always do now, and a news story about Truffaut and its effects came on the TV.
Objection, Your Honor. Hearsay?
Response?
Your Honor, this is not hearsay pursuant to Rule 801, as this is not being offered for the truth of the matter asserted. Instead, it is being offered for the effect on Mr. Weirs, the listener, and how this impacted him and his further actions.
Reply?
Yes, Your Honor, I believe that it actually is being offered for the truth of the matter asserted, as the plaintiff is about to testify that the news report talked about Drufo, which is true.
Response, Your Honor?
Briefly.
Your Honor, what exactly was said in the news report is not being offered for the truth of the matter asserted. Instead, what was said impacted Mr. Weirs to go and do further research into Drufo.
Court will not allow the witness to testify as to what the news report said, but the court will allow the witness to testify as to his response to receiving the news. You may continue.
Did the newscast affect what you did next?
Yeah, after I saw this news story, me and my father went straight to researching Drufo and the effects of it.
And have you ever used lush fertilizer?
I have back at Havens all the time, yeah.
Did you follow any safety measures while using lush fertilizer?
The boss always told us to wear a mask and long sleeve shirts and pants, but none of the other adults did, so I was just doing what they did.
Mr. Weirs, what did you do after you saw the newscast?
I called my boss and asked him to send me a picture of the label on Lush bottle fertilizer.
And did he?
He did, yes.
Would you recognize that label?
Yes.
Mr. Weirs, you should have Exhibit 1 in front of you. Yes. What is Exhibit 1?
This is a picture of the label that he sent me.
Is this an accurate copy of the label as you saw it?
Yes.
Has it been altered in any way?
No.
Your Honor, at this time, we request Exhibit 1 be entered into evidence for its accuracy and authenticity have been shown.
Any objection?
No objection, Your Honor.
Your Honor, permission to publish to the jury?
Yes, Exhibit 1 is admitted and you may publish to the jury.
Mr. Weirs, what stood out to you about this label?
Well, if you look at the label, you can see that there's no actual warning at all. The most dangerous thing it says is an eye irritation, not cancer.
Did anything else stand out to you about this label?
Yeah, if you look at the ingredients, it says it contains Drufo. And when me and my father did more research, we realized that Drufo wasn't in all Lush products or all Lush fertilizers.
What do you mean Drufo isn't in all Lush products?
Well, me and my father found out that Drufo is banned in the EU.
Your Honor, permission for the exhibit to be pulled down.
Yes, you may.
Why, Mr. Weirs, why is Drufo banned in the European Union?
I don't know why. All I know is that I have the cancer.
Mr. Weirs, let's go back to your time let's talk about your sister, Skylar Weirs. Did Miss Weirs work at Havens with you?
Me and Skylar and I did everything together, but Skylar was allergic to the grass, so no, she didn't work at Havens.
To your knowledge, does Miss Weirs have non-Hodgkin lymphoma?
No.
Finally, Mr. Weirs, why are you here today?
Look, this cancer has truly ruined my life. When I go back and think about before I had cancer, I would do things like tutor kids for National Honor Society. I would always hate it. And now I realize I take that for granted. I would do anything to go back to the life that I had before that. And I know that no money can make up for what happened to me, but Lush needs to be held accountable for what they did to me.
Thank you, Mr. Weirs. Your Honor, I have no further questions at this time.
Thank you. Cross-examination.
Yes, Your Honor. Hello, Mr. Weirs. My name is Kendall Kozlowski, and I represent the defendant in this case. And I'm going to be asking you a few questions.
All right.
Let me start off by saying my client and I have the deepest sympathy for your medical condition, but I do have to ask you questions. So just please let me know if it becomes too much for you to answer.
I understand.
Mr. Weirs, you started working for Haven Landscaping when you were 14, is that right?
Yes, I did.
So you worked there for about 4 to 5 years.
Right, yes.
And in those 4 to 5 years, Lush wasn't the only fertilizer you worked with, is that correct?
Lush was one of the main fertilizers we worked with, but it wasn't the only one, no.
And you worked with other chemicals, maybe even more regularly than you worked with Lush.
I wouldn't say more regularly than Lush, but I did work with other chemicals, yes.
And you testified that you did this indoors and outdoors.
It's in my statement, yes.
And there were fertilizers that you used indoors that specifically had safety recommendations that they should only be used outdoors. Is that correct?
I don't know. I didn't look at all the safety recommendations of every fertilizer I worked with.
But you did use fertilizers indoors that were only supposed to be used outdoors.
I don't know. I know I use fertilizers indoors and outdoors. I'm not sure if they're only supposed to be used indoors or outdoors.
Thank you, Mr. Weirs. And your boss even told you to always cover your face when you were working with chemicals.
The boss always told us to wear a face covering, but look, this was before COVID. I mean, I didn't have any face masks readily available. He didn't provide any either.
Right, but your boss told you to do this and you didn't do it, did you?
Objection, Your Honor, asked and answered.
Response.
Your Honor, I don't believe that the plaintiff has answered my question.
The court will allow the question and ask the witness to listen carefully to the question and answer that. Go ahead.
Thank you, Your Honor. I can re-ask the question. Your boss told you to always cover your face, but you didn't always do that, did you?
Like I said, no, and that's because there were no face masks available. He didn't provide any, and I didn't have any. Nobody did.
And Mr. Weirs, you were told to wear long sleeves, but you didn't wear long sleeves.
Sometimes I did.
But you didn't always, did you?
No, not always.
And you were told to wear pants, but you didn't always wear pants?
Not always. None of the other adults did. I mean, like I said, if I showed up to work in a mask, long sleeve shirt, and pants, I mean, they would all make fun of me. I was only 14.
And finally, Mr. Weirs, you were told to wear gloves, but you didn't always wear gloves, did you?
No.
And now could you turn your attention to Exhibit 1, which has already been admitted into evidence?
Yes.
Now you say in your statement that there were no warnings on the label, but it does say hazard on this label, and you agree that the common meaning of that word implies danger.
I said that there is no official warning label. There's only safety recommendations.
But it does say hazard right there, doesn't it?
It says hazard, and it says the most it can cause is an eye irritation or a skin irritation, not non-Hodgkin's lymphoma.
Thank you. Can you read the first 2 sentences under user safety?
Objection, Your Honor, cumulative.
I believe the objection is cumulative. Response.
Your Honor, I'm simply asking the witness to read from an exhibit that has already been admitted.
Court will
Response,
allow-
Your Honor.
Yes, you may.
Your Honor, because this exhibit has already been admitted and published to the jury has access to this exhibit, and therefore having the witness read from the exhibit is cumulative.
Defense has the right to draw the witness's attention to certain texts in the exhibit and ask questions. So at this point, the objection is overruled. You may continue.
Thank you, Your Honor. So, Mr. Weirs, could you please read the first 2 sentences under user safety recommendations?
As with any spray fertilizer, utilize protective clothing that covers exposed skin. Use a respirator or N95 face mask is recommended.
Thank you, Mr. Weirs. And you didn't do that with Lush or any other fertilizer, did you?
Did you want me to read the first 2 sentences?
No, that's sufficient. Thank you so much. And you didn't do that with Lush or any other fertilizer, did you?
Like I said, not all the time. Sometimes I did wear long sleeve shirts and pants. And look, if I would have known that Lush would have caused my cancer, of course I would have followed these rules. I probably wouldn't have worked with the fertilizer at all.
I'm so sorry. I only have a limited amount of time, and your lawyer can clarify anything that you would like further clarified on redirect? Finally, Mr. Weirs, you said earlier that you believe your cancer was caused by Lush fertilizer, but
It was.
you sitting here right now don't know that for certain, do you?
It was caused by Lush fertilizer. I mean, I did the research. Me and my father, we hired experts.
Mr. Weirs, you just testified that Lush fertilizer was just one
We've
of
run
many
out of time.
fertilizers.
I think defense has run out of time.
Thank you.
All right. Redirect?
Yes, Your Honor. Mr. Weirs, why didn't you continue to follow the recommendations made by your boss?
Firstly, he didn't provide any of the safety equipment. And secondly, the adults didn't as well. So I was just followed what they did.
Is there anything on the label that warns of the potential dangers of Drufo?
No, there's not. I wish there was. I truly do.
Thank you, Mr. Weirs. Your Honor, I have no further questions. Your Honor, you are on mute.
Thank you. Court will allow the witness to step down. Is plaintiff resting?
Yes, Your Honor, the plaintiff rests.
Thank you. All right. We'll move to defense's case. First witness for defense.
Your Honor, the defense calls Ms. Doncourt to the stand.
All right. Good afternoon, Ms. Doncourt.
Good afternoon.
Begin. Who's our, there we go. Go ahead.
Can you please state your name and spell your last name for the court?
Absolutely. My name is Blake Doncourt. That's DONCOURTT.
Ms. Doncourt, what do you do for a living?
I work for Lush Fertilizer.
What do you do for Lush Fertilizer?
Technically, I'm the CEO, but honestly, at Lush, we're one big family, so I tend to steer away from the labels.
What does Lush do?
We create fertilizer, sustainable, safe fertilizer, but on a deeper level, I would say we give really good people jobs.
How long have you worked there?
Just since 2000, so over 2 decades, that would make it.
What was Lush like when you first began working?
It was a very small company, practically unknown, so to speak.
And what is Lush's position in the industry today?
We are a sustainable, successful, job-providing company that has not only improved exponentially from the ground up, but we've won awards for it as well.
What are some of these awards?
For example, we earned a SEAL Business Sustainability Award. However, the real accomplishment for me is Lush as a business in total. It's truly my pride and joy, and I couldn't be more proud of the hardworking people that have put so much effort into it.
Can you please tell the jury what makes Lush's products so unique among its competitors?
Absolutely. As I'm sure we're all very aware of the chemical Drufo, it actually was originally created to reduce the number of nitrates that go into things like streams or lakes or large bodies of water. And overall, it has assisted us in fulfilling our goal of saving and helping our planet. Much like our values, we want our products to be just as eco-friendly.
Let's talk a little bit now about the research and process behind Drufo. Can you briefly tell us how Drufo was developed?
Absolutely. I created a team of toxicologists and researchers to look deeper into the chemical of Drufo and essentially research it more in depth. In fact, Carson Durst, who testified earlier, was a part of that team.
What was your relationship with Ms. Durst?
In the past, I would say I had much more of a significant relationship with Ms. Durst. She was a great family friend. But now I would say I don't have as much of a good one, which may help you understand my surprise when somebody I essentially used to consider a daughter is currently testifying against me.
What was Ms. Durst's job while working at Lush?
She worked on what we call the research and development team, and then she soon became one of the product development engineers.
What projects was she a part of during her time at Lush?
Like I said, she was a large part in researching Drufo, as well as other products looking into depth at other chemicals.
Did Ms. Durst ever make you aware of any concerns surrounding your products?
No, she did not. And she worked at Lush for 3 years. So over 1,000 days if I were to ballpark it. And she had every right and opportunity for that matter to come to me, and she didn't.
You say that she had every right to come and talk to you. Can you expand a little bit on this?
Absolutely. For starters, I would like to think that I gave her an incredible opportunity as an extremely inexperienced college student. And additionally, I would like to think all of my employees know that I want to create the most sustainable and safe product. Therefore, they have every right to come to me with any concerns that they might have.
So did Ms. Durst come to you?
No, she did not. And honestly, I guess you could say I was a little bit disappointed, as that's part of fulfilling her duties, to come to me with any concerns that she may have come upon.
Let's talk now about Drufo and its safety. Have you ever had any reason before to believe your products could be dangerous?
No, none of the members of my esteemed toxicology and research team, including Carson, ever brought any concern to my attention. And in addition, in terms of studies on Drufo in total, not just within Lush, I've never seen any valid studies published demonstrating that it's harmful.
Can you please take a look at Exhibit 1, which has been previously admitted into evidence?
Yes.
What is the first active ingredient on this label?
Drufo.
Could you please point out to the jury the right side of the label? Ms. Doncourt, can you please read the first 2 sentences of writing under user safety recommendations?
Absolutely. As with any spray fertilizer, utilize protective clothing that covers exposed skin. Use of a respirator or N95 face mask is recommended.
What was the purpose of this warning?
To give a strong recommendation of what clothing and gear one should wear while handling our products.
You testified a moment ago that you didn't have any concerns about the safety of Drufo, yet Lush included a safety warning. Why was that?
It's simply a requirement. Think of it similar to the nutrition facts on the back of a box of crackers. I mean, even if there's no significant harm to warn about it, I mean, it's just a requirement that you have to have.
You just testified that a key ingredient of your fertilizer is Drufo. Let's return to Drufo. Are you aware that some people are claiming you should have baked Drufo before using it?
Yes, I am aware of that.
And did Lush bake Drufo?
No, we did not.
Your Honor, let the record reflect that I'm asking my opposing counsel and witness to refer to what has been marked as Exhibit 8. Ms. Doncourt.
Go ahead.
Thank you, Your Honor. Ms. Doncourt, could you please look at Exhibit 8?
Yes.
Do you recognize this exhibit?
Yes, I do.
What is this exhibit?
This is a 10-year amortization chart. It's from 2004 to 2014.
Who created this chart?
I did.
And why did you create it?
It's simply a routine thing that many CEOs of a plethora of businesses do. It's something to essentially analyze our costs every once in a while.
Is this a fair and accurate copy?
Yes, absolutely.
Your Honor, at this time, I move for the admission of Exhibit 8 into evidence.
Any objection?
No objection, Your Honor.
8 is admitted. You may continue.
Thank you, Your Honor. Ms. Doncourt, can you please summarize this report?
Yes. Exhibit 8 essentially shows what our costs would be if we were to bake the product.
What did you conclude as far as these costs?
We concluded that since there was no verifiable information regarding significant harm caused by Drufo, that the costs were simply not justified. And let's still be mindful of the fact that I had no verifiable information or awareness that there was need for action for the chemical Drufo.
What impacts would baking Drufo have on Lush?
Not only would it increase our costs, but it would therefore prohibit us from contributing to things that are very important to our business, like donating to charities, for example.
Ms. Doncourt, why have you not implemented baking into your company?
It simply was not justified. Based on 3 years of research, there was never enough risk to justify the amount of time or money or resources that it would take to test something that would simply be unnecessary according to my knowledge of the chemical. I was also never advised to.
You sound pretty certain that Lush did not cause Ms. Weir's cancer or Mr. Weir's cancer. How are you so sure?
Make no mistake, I feel absolutely horrible for the suffering that Mr. Weir's is going through. I simply could never imagine it. However, not only am I aware that my product did not cause this, I'm also aware of the fact that Mr. Weirs worked with a number of other chemicals in his landscaping career. So then I come to the question of why my chemical is the only one being questioned about this.
And finally, Ms. Doncourt, do you have anything to say to Mr. Weirs?
My deepest condolences, truly, to him and his loved ones. But the simple fact is that Lush is not at fault for this, and the science is what matters here.
Thank you, Ms. Doncourt. I have no further questions.
Cross-examination, you may begin.
Good afternoon, Ms. Doncourt. My name is Arapahoe.
Good afternoon.
You are the Chief Executive Officer of Lush Fertilizer,
That is correct.
and you have grown this company into one of the world's largest suppliers of fertilizer,
From the ground up, every step of the way.
and you are extremely proud of this success.
Of course, who wouldn't be? It's one of my greatest accomplishments.
You have worked night and day to build this company into what it has become.
Yes, along with many other people.
But your company is now being threatened by a lawsuit
Yes,
that could cost your company lots of money.
not as much cost us money, but prohibit us, like I said, from contributing to things like charities. I mean, it would
Ms.
be
Doncourt,
detrimental to our company.
Ms. Doncourt, if your company stands to lose this lawsuit, it will cost your company lots of money. Isn't that correct?
Yes, that's correct.
This lawsuit could also cost your company its reputation, couldn't it?
Yes, as I'm sure it would with any other company.
This lawsuit could significantly damage the company that you have worked so tirelessly until today to build.
Yes, that's correct.
Let's talk about Drufo now. Drufo is a chemical within your fertilizer product,
Yes, like I said, it was originally created to reduce nitrates.
and it is an important chemical within your product.
Yes,
It is a chemical that only your company has access to,
yes, that's correct.
and it is a chemical which has been alleged by some people to be carcinogenic,
Incorrectly, but yes.
specifically linked to non-Hodgkin's lymphoma, right?
Yes, I believe that's the claim that's being made.
And Ms. Doncourt, you are aware that non-Hodgkin's lymphoma is a disease that is not genetic.
Yes, I'm aware of the fact.
This means that to contract the disease, someone needs to be exposed to some sort of harmful environment.
Yes,
And one of these harmful environments is fertilizer.
yes, as Mr. Weirs worked with a numerous amount of them.
And because of this risk that fertilizers possess, there are measures that companies can take to reduce this risk.
Yes, like protective gear.
One of these measures is baking their fertilizer,
Yes, that's correct.
because baking the fertilizer is a measure that would eliminate any risk of their product being carcinogenic.
Yes, that's correct.
And your company, Ms. Doncourt, did not bake the fertilizer.
As a CEO, I have many tough decisions to make, and that was just one that I had to make. And it was well educated, well planned, and I do not regret it.
Ms. Doncourt, by not baking the fertilizer, your company was able to increase profits by 6% the initial year.
Instead of looking at the profit increase, I'd rather look at the costs.
Ms. Doncourt, I'm asking you about the profit increase, and it would have increased and it did increase by 6% the initial year, didn't it?
Yes, that's correct.
And each additional year thereafter, profits increased by 2% each additional year.
Yes, that is correct.
And all of this was because your company did not bake the fertilizer.
Yes, one of many decisions that I have to make as a CEO.
You, as the CEO, Ms. Doncourt, made the decision to not take this measure that would eliminate any risk of your product being carcinogenic because you deemed it too costly.
Sorry, I believe there was an objection. I'm not sure if I heard it, but.
Is there an objection?
Yes, Your Honor. I believe that this question has been asked and answered by my witness.
Response?
Your Honor, I have not yet asked Ms. Doncourt this question of whether this measure of baking Drufo was specifically too costly for her company.
Any reply?
No, Your Honor.
Objection is overruled. Witness is instructed to answer the question. Do you need it repeated?
That would be wonderful. Thank you.
Thank you. Go ahead.
Ms. Doncourt, you as the CEO made this decision to not take this measure that would eliminate any risk of it being carcinogenic because your company deemed it too costly.
It was more deemed that there was not enough risk to justify it. And yes,
Ms. Davenport,
be
it is
that
your
the
words that it
but-
was too costly to take this measure.
because of the risk not being justified, yes, you're correct.
Because it was too costly.
Because there was no risk being justified, yes.
No further questions, Your Honor.
Redirect?
Yes, Your Honor.
Go ahead.
Ms. Doncourt, would you ever put money over people's health?
Absolutely not. I mean, not only do I run a business, but I provide jobs for people. I'm constantly around people and I care about nothing more than the health and the well-being of my employees.
And Ms. Doncourt, did anyone tell you about the true risks that Drufo could impose on your products?
No, not at all.
Thank you. I have no further questions.
The witness may be released. Next witness.
Your Honor, the defense calls Skylar Weirs to the stand.
All right. We have our opposing counsel. There we go. All right, you may begin.
Good afternoon, Ms. Weirs. Can you please state your full name and spell your last for the record?
Of course, I'm Skylar Weirs. It is Weirs.
And Ms. Weirs, what is your relationship to the plaintiff?
I'm Dakota's loving sister.
And what do you do for work?
I'm a prominent investigative journalist.
What do you do as an investigative journalist?
Well, I work mostly unveiling the conflict between corporate policy and individual health, which includes several areas of expertise in order to develop scientifically accurate studies.
What publication do you write for?
The Rationalist.
For those of us who aren't familiar with this publication, can you tell the jury what The Rationalist is?
Of course. The Rationalist is a quarterly science education and science advocacy magazine published by the Rationalist Society, which is a nonprofit organization devoted to promoting scientific skepticism and resisting the spread of pseudoscience, superstition, and irrational beliefs.
And Ms. Weirs, what area has your work focused on?
Agritech mainly, which is an industry that has been attacked by pseudoscience. I know I don't have a college degree, but my knowledge base involves general knowledge plus historical and statistical information. And you don't need a degree for that. In fact, outside of the USDA and the NASDA, I doubt anyone has the overall perspective on modern agritech that I do.
You're talking about agritech. Can you explain to us what agritech is?
Oh, sorry. Sometimes I forget that everyone doesn't already know, but agritech is simply as it sounds, technology that is developed to improve efficiency and yield of agriculture.
And what research have you done specifically on agritech?
I've spent a considerable amount of time researching agritech companies by reviewing publications written by those companies, researching studies referenced in those publications, and looking at information maintained by the USDA and the NASDA.
And how much time did you spend on this research?
I spent a full year reading and researching from scholarly sources.
In addition to agritech, is there any other topics that you've researched?
Oh, yes. I also researched the conflict between individual health and corporate policy.
Your Honor, at this time, we move to have Skylar Weirs admitted as an expert in the field of agritech under Rule 702.
Any objection?
Your Honor, pursuant to your pretrial order, Ms. Weirs has hit the elements you require to be able to be tendered as an expert in the field of agritech.
So no objection.
No objection, Your Honor.
The witness will be so qualified. You may continue.
Thank you, Your Honor. Ms. Weirs, I want to return to talking about pseudoscience. What is pseudoscience?
Well, I guess basically it's a collection of beliefs, or you could say practices, mistakenly being regarded as science when actually it's false.
And how does pseudoscience relate to lush fertilizer?
Well, the so-called old guard of the agritech sector is spending billions of dollars to destroy the reputation of Lush fertilizer because Lush's patent breakthrough Drufo threatens to upend their entire business.
Is this practice of undermining companies and their scientific basis new?
As crazy as it might sound, these bought and paid for pseudoscientific hit jobs are nothing new in the world of agritech.
Can you give us an example of a hit job that you've seen?
Well, I mean,
Pursuant to Rule 401, relevance.
Response?
Your Honor, the witness is explaining about agritech and about how campaigns against agritech have hurt businesses, which does relate to Lush fertilizer.
Response, Your Honor.
Yes.
Your Honor, other companies being attacked in pseudoscientific hit jobs is not relevant to Lush or proving Lush's negligence.
The court will allow a short question and answer as preliminary laying the groundwork, but court will ask defense to keep its questions limited.
Thank you, Your Honor. Can you give us an example of a hit job that you've seen, Ms. Weirs?
well, yeah, as I was saying, Monsanto, as I'm sure you've heard of, it was a revolutionary agrochemical company. And it was so good, it was on the verge of monopolizing the corn industry when its competitors effectively launched an aggressive PR campaign to disrupt the genetically modified crop from the market. But hundreds of studies have shown that they are safe and even have the potential to help end world hunger.
In your research, did you find any similarities between this and the campaign against Drufo?
Yeah, Drufo works a miracle in the herbicide industry, and its revolutionary technology scares competitors and gives them a motive to start a pseudoscientific attack similar to those against Monsanto.
And now I'd like to talk about Drufo. How do these misinformation campaigns that you just talked about affect Drufo specifically?
Well, I've seen the same pattern repeat itself as advanced technology reaches the market and often has the potential to seize the industry. It suddenly is attacked, whether for safety or lack of research. These products are often good and don't reach their capability because of these attacks.
And how does this relate specifically to Drufo, Ms. Weirs?
Well, before Dakota got sick, I published an article based on my agritech research formulated from research I reviewed about the false myth that there is a connection between Drufo and cancer. Therefore, I stand for the science when I say that it is a misinformation campaign trying to take down Drufo.
Can you tell us about some of the potentially harmful effects of agritech in general?
Yeah, well, to be frank, all fertilizers and pesticides are poisonous to some degree, as their job is to literally kill undesirable organisms. But based on my research of these agritech products, Drufo is by far the safest of the industry line. Lush has created a product with far less nitrogen than its competitors.
Along with these environmental benefits that you just talked about, are there financial benefits to using these new kinds of agritech?
Well, Drufo, for example, only needs to be applied once or maybe twice a year, so you don't need to buy as much product. Other grass fertilizer needs to be applied 5 or even 6 times per year to achieve the same nitrogen penetration. Because Drufo reduces the solubility of Lush fertilizer, the nitrogen in this product is also less likely to contaminate groundwater and waterways.
And now, Ms. Weirs, I'd like to turn and talk about your relationship with Dakota. You told us a few minutes ago that you and Dakota are twins. Can you tell us about your health today?
Yeah, I'm in spectacular health.
And could you tell us about how your different lifestyles could have contributed to this difference in your health?
Well, based on my agritech research, it wouldn't surprise me if Dakota developed non-Hodgkin's lymphoma based on past exposure to a whole host of products that contain carcinogens from Dakota's work in landscaping.
And finally, Ms. Weirs, why are you testifying here today on behalf of the defendant against your twin?
Well, my motto in life is science over speculation, and I have devoted my entire career to science, and I can't go against what I know is right.
Thank you, Ms. Weirs. No further questions. Your Honor, I pass this witness for cross-examination.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Weers. My name is Feliciana Sayers.
Good afternoon.
Let's talk about your research. You authored one article questioning the narrative that there is a causal link between Truffaut and cancer,
It was a part of my series on agritech.
but you only authored one.
Yeah, after extensive research.
In fact, you doubt anyone has the same overall knowledge on modern agritech that you have.
Yeah, outside of the USDA and the NASDA, I have a lot of knowledge. In fact, a very unique perspective.
Yes, Ms. Weers. Despite all of this knowledge, you are unaware of any study that establishes a causal link between Truffaut and cancer.
Correct.
But you did extensive research into modern agritech.
Correct.
Despite your extensive research, you are unaware of the British study on the compound C3N09P, an ingredient in Truffaut, and it's causing cancer.
Well, all fertilizers and grass seeds are by definition poisonous. However, what I'm
It's
saying,
weird. That was not my question. My question was, despite your extensive research, you are unaware of the Mattis Bernard Cancer Research Center's study on
Objection, Your Honor,
compound.
this question is out of the scope of my direct. I'm so sorry.
The objection is beyond the scope of direct response from plaintiff.
Your Honor, my cross-examination does not need to fall into the scope of the direct examination.
Any response?
Your Honor, I believe that the cross-examination does need to fall within the scope of direct examination.
I believe that it is with within the discretion of the judge. So I will allow it. You may continue.
Yes, Your Honor. Ms. Weers, despite your extensive research, you are unaware of the Mattis Bernard Cancer Research Study on the effects of the compound C3N09P in Truffaut causing cancer in rats.
sorry, did you say in rats?
Yes.
Oh, I've mostly been doing research on how agritech, and my article was about how Truffaut affects humans.
But nonetheless, you are unaware of this study.
I don't study rats, I'm sorry.
And because you are unaware of this study, it did not factor into your opinion.
No, I'd love to see the study after this.
Ms. Weers, you work for the Rationalist magazine,
I do.
and they're devoted to preventing the spread of pseudoscience, superstitions, and irrational beliefs.
That's right.
You, on many occasions, have challenged the major players in agriculture.
I have.
You have lost out on many potential job opportunities because of those opinions.
Yeah, it's hard to be the underdog.
But now your work is generating income.
Yeah, I mean, not a lot, but income.
You are here today testifying for Lush Fertilizer.
That's right.
You are aware that Lush is a major player in agriculture.
Yeah,
In the past, you have stated your support for Monsanto.
that's right.
You are aware that Monsanto is a major player in agriculture.
Yeah, not anymore, but they were.
Let's talk about fertilizers.
Okay.
You believe that no chemical fertilizer will ever truly be safe.
I mean, as technology advances, they keep getting safer and safer.
But you believe that no chemical fertilizer will ever truly be safe.
Yeah,
Every commercial fertilizer contains several well-known carcinogens.
yes.
And pesticides are poison.
By definition, they are poison because they're killing undesirable organisms. However,
Your Honor, I have no further questions at this time.
Just as a point of clarification, I do believe according to the rules that it's recross that has to be limited to the scope of redirect.
Yes, Your Honor.
Okay, so we weren't quite there yet. All right. Go ahead. Redirect.
Just to summarize, Ms. Weirs, in your review of research on agritech, have you found any reliable scientific research indicating a link between DRUFO and cancer?
No, I'm not aware of any study that has established a link between DRUFO and cancer with any level of certainty. In any event, Lush Fertilizer's development of DRUFO actually protected consumers by eliminating exposure to carcinogens.
Thank you, Ms. Weirs. No further questions.
May this witness be excused? All right, the witness may be excused. Anything else for defense?
Yes, Your Honor. The defense calls Dr. Devin Williams to the stand.
All right, good afternoon, doctor.
Good afternoon.
You may begin.
Hello, Dr. Williams. Could you please introduce yourself to the jury?
Good afternoon. My name is Dr. Devin Williams, Williams.
Dr. Williams, where are you currently employed?
I work at Lush. I'm also an assistant teacher at University of New Mexico College of Pharmacology, and I've previously worked as a chief medical examiner toxologist.
What is your role with Lush?
I initially started as a technician working with DRUFO development, then was promoted to lead the toxicology research and development labs at Lush, and I'm the outgoing chair of the company's ethics committee.
How long have you worked for Lush?
I started my career with Lush roughly a decade ago and have led the toxicology labs for 7 years now.
Let's go into your qualifications to hold this job. What degrees have you earned?
I have a Bachelor of Science degree in pharmatoxicology and a Master in Science of Forensic Toxicology specialization, along with a PhD in pharmacology and toxicology.
Do you hold any other certifications?
Yes, a Colorado Department of Public Health and Environment Laboratory Director Certificate of Qualification, focusing on forensic and clinical toxicology.
Finally, how do you utilize your training and experience while working for Lush?
I research and evaluate tests to determine if a substance is going to harm the average human and how to neutralize that harm if it happens.
Your Honor, I move to admit Dr. Devin Williams as an expert witness in pharmacology as well as clinical and forensic toxicology.
Any objection?
No objection, Your Honor.
Witness is qualified as an expert in pharmacology and clinical and forensic toxicology. You may continue.
Thank you, Your Honor. Dr. Williams, what are you here to testify to?
I'm here to testify based off my education and experience that DRUFO does not increase one's chance to get non-Hodgkin's lymphoma compared to other fertilizers.
Could you elaborate on that?
DRUFO has not been correlated with a statistically significant increase in the incidence of non-Hodgkin lymphoma or any other cancer.
What statistics are you referring to?
The data I analyzed while working for Lush.
And what did this data show you?
All of the data we looked at showed that users of fertilizers with DRUFO did not have an elevated risk of non-Hodgkin's lymphoma compared to users of other fertilizers.
How did you come to this conclusion?
When we analyzed the data for DRUFO fertilizer, there was no statistically significant increase of developing non-Hodgkin's lymphoma with the use of DRUFO than there was without it.
Can people not exposed to chemicals develop non-Hodgkin's lymphoma?
Yes, unfortunately, no matter the circumstances in a group of people, some will develop non-Hodgkin's lymphoma and others may not.
And what kind of people did the data look at?
We looked at users of DRUFO fertilizer and users of fertilizers without DRUFO and found no notable difference in the number that developed non-Hodgkin's lymphoma.
And why was that significant?
Because it demonstrated that the use of DRUFO has no correlation to an increase in developing non-Hodgkin's lymphoma.
Let's discuss the ban of this product in France. Are you aware of this ban?
Yes.
Do you know the reasoning behind it?
Yes, to the best of my personal knowledge, Drufo is not just banned in France, but all of the EU under the European Nitrate Directive to relieve environmental stress, but not because it causes cancer.
Do you do any work with the EU Nitrate Directive?
My department is finishing a study that expects to prove that Drufo-based products are not harmful to the environment. With the completion of this study, we plan to resubmit our findings to the EU for reconsideration.
You explain this directive?
No new fertilizer formulations may be used that contribute more than an incidental nitrate accumulation in lab tests in an attempt to better the environment.
Why does this apply to Drufo?
Because in lab settings, Drufo contributed too many nitrates, but it doesn't in nature and uncontrolled areas. In fact, it is actually better for the environment than traditional fertilizers.
I'd like to turn our attention to a study done by Dr. Rogers about the carcinogenic effects of Drufo. Are you familiar with this study?
Yes.
What is your professional assessment of this study?
The study is flawed as it basically compared apples to oranges and made a statement based on the results.
What do you mean by apples and oranges?
Rogers looked at exposure to Drufo for farm laborers versus casual gardeners versus people who didn't do either of those things and compared rates of non-Hodgkin's lymphoma.
And why is this important?
Because Drufo isn't the only difference between the groups of people he looked at. They have different lifestyles and are exposed to different products and environmental conditions, such as pesticides and herbicides.
Why do these different environmental exposures matter?
It is possible that farm laborers and gardeners in general have a higher incidence of non-Hodgkin's lymphoma. Simply, this has nothing to do with Drufo, but everything to do with other environmental exposures.
What would have been a valid form of this study?
A valid study would have needed to compare something like farm laborers who use Drufo fertilizer to farm laborers who use fertilizers without Drufo.
Was there anything else wrong with this study?
It has not been peer-reviewed or replicated. Without being replicated, we cannot draw reliable conclusions from this data, especially due to the fundamental flaws.
Finally, in your expert opinion, do you believe Drufo causes cancer?
No, it does not. And I do not believe there's any valid evidence to support the plaintiff's claim that it does.
Dr. Williams, thank you for your testimony. Your Honor, I have no further questions.
Cross-examination.
Yes, Your Honor. Good afternoon, Dr. Williams. My name is Moira Newman. I'll be asking you some questions today.
Good afternoon.
I'm the outgoing ethics committee chair, isn't that right?
Yes.
Yeah, so it was your job not to consider the benefit of the company to the detriment of your customers.
Can you please repeat the question?
Of course. I can even rephrase if you would like.
Yes, please.
It was your job to put your customers first. Isn't that right?
Yes.
Right. Now, you believe that there is no valid evidence that Drufo causes cancer.
Exactly.
You believe this because you looked at data that compared users of Drufo with users of products not containing Drufo, right?
Yes.
And all that data was consistent with users of Drufo not having elevated risk of developing cancer than users of the old generation of fertilizers. Isn't that right?
Correct.
Now, you also believe that Drufo is far safer for the environment than other fertilizers. Isn't that right?
Yes.
You believe this because less fertilizer needs to be sprayed to reach the same effect as the old generation.
Exactly.
So users of Drufo had no elevated risk of developing cancer as compared to people who used the old generation of fertilizers way more frequently than using Drufo. Isn't that right?
Yes, there was no statistically significant increase in developing non-Hodgkin lymphoma.
That's right. You believe there is no statistically significant increase in the development of non-Hodgkin lymphoma. Yet nowhere in your statement do you include your error rate for what is and is not statistically significant.
I didn't.
So we will never know what your error rate for what is and is not statistically significant in developing cancer. Isn't that right?
I'm an expert in evaluating tests and coming up with conclusions based off of the studies that I evaluate. And it is my expert opinion that doesn't have a statistically significant increase, but no, I did not include it.
And we will never know what your error rate is. And we will never know what your standard rate for regression analysis even is.
No, but I am an expert.
Is there an objection?
Objection cumulative.
Overruled. You may continue.
Now, Dr. Williams, you attempt to discredit Dr. Rogers in your statement.
Yes, I do not think that Dr. Rogers' study was reliable.
That's right. Now, Dr. Rogers, his entire career is focused on finding the adverse effect of chemicals on the human body. Isn't that right?
Yes.
And you were once the ethics committee chair, isn't that right?
Yes.
And you believe that if someone finds what they set out to find, one should always question their results. Isn't that right?
Yes, but in this case, the results are not valid.
But you do believe that if someone sets out what they expected to find, one should always question their results?
Yes.
Now, your lab is leading a study based on eutrophication, isn't that right?
Yes.
And you expect that the results will overturn the ban in the EU, and Drufa products will be sold to a whole host of new customers, isn't that right?
Yes.
A whole host of new opportunities for profit, isn't that right?
Correct.
And in fact, a whole host of new opportunities for what you believe is a environmentally friendly product, isn't that right?
Yes, it is environmentally friendly.
Right, you believe this, and indeed you're sad that the jury will only look at Drufo's effect on people, on whether it causes non-Hodgkin lymphoma in a vacuum. Isn't that right?
Yes.
You're sad that the jury will not be able to weigh the benefits of what you believe is a frankly revolutionary product.
I do, but there's also no evidence that that Drufo causes cancer.
Dr. Williams, that wasn't my question. My question is that you're sad that the jury will only be able to look at whether Drufo causes cancer in a vacuum. And you are, isn't that right?
Yeah.
But you say that it doesn't, which is fortunate for Lush, for its competitor, for its stockholders, and for the planet. Isn't that right?
Yes.
And that's the exact order that you gave.
Yes.
Thank you. No further questions, Your Honor.
Redirect?
Yes, Your Honor. Dr. Williams, during your work at Lush, did you ever analyze any data that showed that there was a carcinogenic effect to Drufo?
No, I did not.
And could you reiterate one more time why Dr. Rogers' study is flawed?
Well, Dr. Rogers' study is flawed because he compared his control study.
According to Montreal Rules of Evidence 403, this is wasting the jury's time, as Dr. Williams has already gone into extensive amount of detail on why she thinks Dr. Rogers' study was flawed.
Is your objection cumulative?
Cumulative, as well as wasting the jury's time.
Response?
Yes, Your Honor. As on recross, as we established previously, I can question the witness based on the scope of the cross-examination. So I'm just clarifying some points that were asked during the cross-examination.
I'll allow clarification. Overruled.
Would you like me to repeat the question?
Yes, please.
Could you just clarify one more time why you believe that Dr. Rogers' study was flawed?
Well, Rogers looked at exposure to Drufo for farm laborers versus casual gardeners versus people who didn't do either of those things. And therefore, Drufo isn't the only notable difference between the groups of people he looked at. As well, his study has not been peer-reviewed or replicated.
And finally, do you believe that Drufo causes cancer, Dr. Williams?
No.
Thank you, Your Honor. I have no further questions. The defense rests their case.
Thank you. Anything else that needs to be addressed before closing arguments? All right, hearing nothing, plaintiff may begin with closings.
Yes, Your Honor. Green lawns plus greenwashing equals greenbacks. Dakota Weirs is stumbling towards the piano. He's hoping for the music of his childhood to break his everyday pain. His hands desperately reach for the keys, but his arms don't leave his side. Silence stretches on while he sits, trapped in this shell of a body, devastated with the knowledge that his life's joy is gone. Good afternoon, Your Honor, counsel, members of the jury. My name is Moira Newman, and together with Feliciana Sayers and Arapahoe, we have the privilege of representing Mr. Dakota Weirs, the plaintiff, in today's trial. Our burden: prove Lush was negligent, and that its negligence damaged Dakota Weirs. We have met our burden. At the beginning of this trial, Ms. Sayers asked you to remember these 3 questions. 1, did Lush do enough to warn and protect its customers? No. Carson Durst told the company about her concerns regarding Drufo. Response: more tests to reach better conclusions, but better for Lush. Dr. Williams, the ethics director, placed Green Lawn's profits over true and legitimate customer safety. Doncourt, the humanitarian savior, no warnings, no baking, more money. Greenbacks. Question 2. Hold a 14-year-old accountable to protect himself. He couldn't even choose his own bedtime, but the defense expects him to have the maturity to act in his own best self-interest. Grown adults weren't even wearing the mask around him. Why would he? And finally, 3, Drufo safe. Now, Drufo creates green lawns, and the defense would like you to believe that it's better for the environment as a whole with no elevated risk of developing cancer, which is greenwashing. However, Dr. Rogers' study proved that being exposed to Drufo once is just like being exposed to arsenic 10 times. The defendant's own attorney, Ms. Hopper, even asked, were you aware of the true risk of Drufo? Which Ms. Doncourt denied. Members of the jury, Drufo was designed to kill. Its original intention may have been for pests or weeds, but a killer is a killer nonetheless. Green lawns plus greenwashing equals greenbacks. We are not claiming economic damages here today, but Mr. Weirs has suffered. He is suffering great pain, and he has lost the quality of the life he would have had. It is up to you to put a value on that loss, that pain. $5 million is certainly not an unreasonable amount. Find Lush Fertilizer liable and award Dakota Weirs at least $5 million. Thank you. Also, Your Honor, I would like to reserve any time I have left for rebuttal at this time.
Thank you. It's reserved. Defense closing.
Yes, Your Honor. Ladies and gentlemen of the jury, the plaintiff tried to tell you that this case is about greenwashing, And as we haven't received any evidence on what that means, I will tell you very clearly right now that this is a case about prioritizing science over speculation. Now that you've heard all of the evidence, Lush Fertilizer asks you to disregard emotional pleas, speculation, and instead focus on the science. The science simply does not link Lush Fertilizer to the plaintiff's cancer. And while it is tempting to want to blame someone for Dakota's illness, the blame should not fall at the feet of Lush Fertilizer. The plaintiff has the burden of proving negligence in this case. That means that the plaintiff needs to prove that it is more likely than not that Lush was negligent. In order to prevail on their claim of negligence, the plaintiff has to prove all 4 elements in jury instruction 2 by a preponderance of the evidence. However, the plaintiff today hasn't proved at least 2 of them. The first is that for the defendant Lush Fertilizer to be found liable, the plaintiff needs to prove that Lush was negligent in not taking reasonable safety measures. The plaintiff has tried to tell you that the CEO of Lush, Ms. Doncourt, was negligent. She wasn't negligent because she was never presented with any reliable, conclusive evidence that there was any risk to her customers that needed to be mitigated through baking. The second element is that the plaintiff had damages that were caused by the defendant's negligence, while the fertilizer was being used in a manner Lush should reasonably have been expected. You heard that Lush Fertilizer had a warning label that the plaintiff chose not to follow. Lush Fertilizer had a burden of proof today too, and unlike the plaintiff, Lush met its burden of proof. Even if all of the science is disregarded in this case, and you, ladies and gentlemen of the jury, find the defendant negligent, you as jurors must also take into consideration that even if the product was dangerous, and it's not, Dakota's own conduct contributed to his injuries. This is the affirmative defense of comparative negligence. While Lush is sympathetic towards the plaintiff's condition, you heard Dakota Weirs testify that there was a warning label on the package and he didn't follow it. And you heard that he was advised to wear protective clothing and he didn't do that either. The plaintiff has cancer and the natural instinct is to want to blame someone. But based on the scientific evidence presented, Lush should not take the blame. Blake Doncourt, the CEO of Lush, told you she was never presented with any reason to think her product could be harmful. Skylar Weirs testified about the misinformation campaign surrounding revolutionary agritech products such as Drufo. And finally, Dr. Williams told you herself that Drufo is not correlated with any serious health conditions. Weighted against all that science is the lack of science the plaintiff presented to you. Their expert witness, Dr. Rogers, testified they only studied 1 fertilizer, ignoring any other toxins in the people they studied were also in contact with, meaning that there is no possible way any increase in serious conditions in the participants in their study could solely be attributed to Drufo. You also heard from former Lush employee Carson Durst, who admitted she works for a competitor of Lush, and in doing so violated a confidentiality agreement she had with Lush not to share trade secrets. Finally, the plaintiff is angry. They want to blame someone for their illness, but as they testified to you here today, they simply didn't follow the proper safety precautions that they were supposed to while using any fertilizers. And as a result, they don't know with 100% certainty what caused their cancer. Ladies and gentlemen, Lush Fertilizer is not at fault here. The plaintiff has failed to meet their burden by a preponderance of the evidence, and based on the scientific evidence we showed here today, as well as a lack of evidence conclusively connecting the plaintiff's cancer with his use of Lush Fertilizer, we ask that you not allow your sympathy for Mr. Weirs to influence your decision. We ask that you base your decision on science and find that the plaintiff failed to meet their burden in proving Lush Fertilizer was negligent. Thank you.
Rebuttal?
Yes, Your Honor. Lush Fertilizer has created a balancing act between environmentalist, greenwashing, marketing gimmicks versus true and legitimate customer safety, and they should be held responsible for the collateral damage it causes. The defense would like you to believe that Lush holds science over speculation. But based on the evidence presented here in trial today, we know Lush held profits over science. Ms. Doncourt choosing to bake ingredients put her customers at risk for profit. Devin Williams hoping to put a dangerous product on the market for profit. The science we presented to you today, Dr. Rogers, someone who has had over 20 years of experience in his field, told you the true science of today's case. Give some of those greenbacks back to the person Lush failed to protect. Find Lush Fertilizer liable. Thank you.
Thank you. All right. At this point in time, we will allow the scoring panelists a few moments to finish their scoring, and then we'll allow them to give a few comments. I think we're running a little bit beyond by time, so we'll try to go as quickly as possible, but let's give those scoring panelists an opportunity to finish up their scores.
Who's the lights of this room? How's that? What's going on now? Anybody in to see it? Some more of nothing? More of nothing?
All right, looks like we have our scoring panelists back. Were you all able to submit your scores? Are the
Yes, Your
scores all in? Scores are all in? Great. All right. Mr. Matisse, go ahead. Do you have any feedback for our student attorneys?
Yes, thank you, Your Honor. I know that we're running a little late, so I'll keep my comments brief. I thought the themes on both sides were very good and very consistent. Be a little careful on your opening that you try to be non-argumentative, and argumentative doesn't mean arguing in the usual sense, but it usually means basically just presenting the facts that are going to be presented and the witnesses and your theories and avoid some of the argumentation there. I thought that most of the exams were very good by both teams. In particular, emphasizing the finishing up on a strong note. I noticed that, for example, Ms. Newman, your redirect examination of the first witness was very good, in that it ended up on a very strong note.
Something else I could help with?
Oh, sorry about that. My Siri's talking to me. The other thing I want to point out is just be careful. Oh, I'm sorry, what's going on here with this? The other thing that I'll keep in mind is, especially with Zoom, is try to avoid talking over each other, especially the witnesses. If you're making an objection, I know that can be somewhat hard to do, but it can sometimes be annoying to the jury if it looks like you are trying to cut someone off. But overall, I thought it was very good. I thought the closing arguments on both sides were quite excellent. The one thing I'd point out is that the rebuttal, when the plaintiff saves some time for rebuttal on a closing argument, it's really a good idea if you can just hit one or two things that the opposing side either failed to do or point out some contradiction in that, because that's much more powerful than just simply resumming up your same argument. Thank you.
Ms. Kerrigan.
I have done this for the last several years, and I'm more impressed every year with how polished everything gets. And I think you all did really fantastic. The level of courtesy and professionalism that you all show to the court, to the witnesses, to the other attorneys is great. And today, dealing with your adverse witnesses, those of you that had to do that, you all did very well. You know, when you're asking that yes or no question and you can't get them to stop talking, and the little tricks you had to try to turn things around, I thought that was really great. I know it really shows how much prep work you've all done. And then on top of that, as you know, you're here having to remember everything, but also think on your feet. And I just thought everyone did so great with that. And I know it's the first day, so that's really impressive too, that it's only going to get better from here, I think. If there's anything I can think to sort of give hopefully a constructive criticism is there were a lot of questions that were just statements where the attorney makes a statement and waits for the witness to say yes or no. I guess, and I know some of you could throw that on the end. I think, Ms. Newman, is that correct? You know, and you throw a question in there. So I guess that's something you can always object to if that keeps going on, or you can change it yourself. But in general and overall, I just thought you all did fantastic, and your work really showed.
Mr. Adams.
I want to mirror, everyone did a fantastic job. My 2 cents would be, in our closings, if we're going over jury instructions or the law, lay it out. You need to prove this. They didn't prove it by XYZ, or they did XYZ, kind of laying it out to the jury, not just explaining they have to prove negligence and then let the jury figure out the jury instructions. That's your chance to lay it out to them and kind of help them along the way, or guide them in the way you want them to go. My other thing would be, slow down a little bit and listen to what either the witness or opposing counsel is saying, because a handful of objections were resolved if you had just let someone finish their sentence, wait for a natural pause for an objection. But overall, it was great. And it was fantastic to watch everyone.
Yep, absolutely. You guys, both teams, you did a fantastic job. Sometimes we like to throw you a little curveball and make you think on your feet. And you guys, you rose to the challenge. You did a great job. So congratulations, round 1 under your belt. And wish you both best of luck going forward. You guys are awesome.
Thank you.
Thank you.
Thank you, Your Honor. Thank you.
Good luck.